All right, good afternoon, everyone. We're going to go ahead and get started today. Just a little housekeeping before we get into our content. Please remember that these webinars are intended for educational purposes only. While we do hope that you learn new information, the trainers presenting these webinars are not attorneys. Therefore, all information provided during the presentation and the Q&A session should not be construed as legal advice. All right, now that that is out of the way, good afternoon, everyone. My name is Brianna Grimes, and I'm going to be your trainer facilitator today. For our state 2021 updates, we are covering Georgia, Florida, South Dakota, Oregon, and Virginia today. So I'm sure you will have a lot of questions. There's a lot of content to cover today. So please feel free to type any questions that you have into the question box as we're going through the presentation. Now, some of your questions may not have immediate answers as these are new or expanded laws and they are subject to legal interpretation, but we will do our very best to get you the answers that you need in order to take any actions that you need to for your company. Also, I was having some technical difficulties earlier with regards to the handout, so I will email a copy of this presentation in PDF form at the end of the presentation today, and then this session is being recorded, so you will also get a copy of the recording sometime tomorrow afternoon. All right, with that being said, let's go ahead and jump in. All right, so today we're going to be talking about specifically in Georgia, Senate Bill 288 and Senate Bill 443, talking about criminal background checks and wage garnishments. In Florida, we're going to talk about minimum wage and mandating EVerify. In South Dakota, we'll talk about their minimum wage changes and the legalization of marijuana. And in Virginia, we will be talking about their minimum wage change, worker misclassification laws, and handheld devices while driving laws that have been updated. And then in Oregon, we will talk about the minimum wage change that is happening there. All right, let's jump into Georgia. So first, let's start by talking about Senate Bill 288. Essentially, this will go into effect on January 1st of 2021, and it allows rehabilitated individuals to petition the court to restrict and seal certain criminal records. So in other states, this is better known as expunging criminal record history. In addition, this bill prohibits the use of an employee's criminal history information in any action against an employer for the employee's actions. So just really a change to the criminal background checks that are coming up. Keep in mind that if you, really the implication here is that if you had someone apply to your company in the past and you kept their file or their application on file, and then they did not pass that background check, I would highly recommend if they do reapply for a position with your organization that you rerun that background check, as they may have qualified under this new Senate bill to have some of their record expunged. And part of that record may have been what caused them to not pass that background check. So you are not able to really determine their employment eligibility based on any previous background checks that you had run prior to this law becoming effective. So just keeping that in mind for any duplicate applicants that do come by your doors that you have processed in the past that just really didn't quite make it past that background check. Now, as far as action items go, there really are none at this time for this particular law. It's more of an FYI, and just kind of keep that in mind. Really, the implication that I talked about earlier with people who are reapplying to your company is really the main implication for employers at this point. But I am sure that the language surrounding this particular law and hiring practice may be updated on the 2021 labor law posters. We haven't heard anything so far. I'm not sure it'll be announced probably in the coming weeks. But make sure that you do get your updated posters for the beginning of the year for any laws that have changed or updated, or some of the language may have been modified. If you are working 100% remote, or you do have some remote employers, employees, Pay Entry is beginning to offer e-posters starting in 2021. So if you are interested in our e-poster service, you can definitely email myself or Kathy at the end of this presentation, and we can get you pricing on that. But it's a great way to stay compliant with all of your employees working remote or at different locations. So definitely a viable option for you guys coming into the new year. All right, so the only other real change in Georgia was the passing of Senate Bill 433, which also goes into effect on January 1st of 2021. And this particular Senate bill limits the amount of wages that can be garnished for student loan repayment. And it limits it to 15% of the garnishee's weekly disposable earnings. So as far as action items go, there really are none at this time. Again, this one is more of an FYI. If PayEntry is your payroll provider, we will be updating this in our system for any of our Georgia clients. But definitely if you are not a payroll client, I would still recommend that you reach out to your your payroll provider, and just verify that they are limiting any of these garnishments if you do have any employees that are being garnished for their student loans. All right, next let's go ahead and talk about Florida. So there's not much legal activity happening in Florida in 2021, but their minimum wage is changing. Beginning on January 1st of 2021, the minimum wage in Florida will increase to $8.65 per hour. Now, another thing to keep in mind, especially with Florida as we look forward into the new year, this past November, Florida actually passed Amendment number 2 with a 60.8% majority vote. And that is now going to be increasing its minimum wage each year going forward until the very last increase in September of 2026. So pretty much every year from now until 2026, Florida will be having their minimum wage increased. In 2026, they are aiming to have the minimum wage reach $15 an hour. So that's a huge increase, a huge jump from the $8.65 an hour it will be this upcoming year. So the next minimum wage change is not going to happen until September of 2022. So you get a little bit longer of a year to prepare for the next big jump, and rightly so, because the next big jump that's going to happen in September will be going up to $11 an hour. So in September of 2022, you're going to go from a minimum wage of $8.65 to $11. So as far as action items go, be sure to conduct a wage audit to identify any employees that will not meet that minimum wage of $8.65 an hour in 2021, and prepare to adjust their wages so that new pay goes into effect before the new year. Also, knowing that there will be that large jump coming in 2022, I would definitely recommend start preparing for that payroll increase and strategizing for your organization how many employees are going to need a significant pay raise in order to eventually meet that $11 an hour in September of 2022. For your company particularly, it might be easier for you to adjust the pay rates in your company maybe every 6 months, every 8 months, or something like that to slowly reach that $11 amount instead of doing that large lump sum change in 2022. So just something to consider with that big bump coming. All right, and the only other law that's really changing in Florida is regarding EVerify usage. So this law goes into effect again January 1st of 2021, and it basically mandates that EVerify must be used for all public organizations and all private organizations with public sector contracts. And this includes anybody with subcontractors in public contracts. So in addition, under the new Florida law, any private employer who does not use EVerify must also maintain copies of the documents used to complete the Form I-9 for 3 years, which is optional under federal law. So just keep in mind, if you are not a public organization or a private organization with public contracts, then this wouldn't apply to you, but this is the mandated EVerify law that is going into effect in January. As far as action items go for this law, if this applies to your organization, you will need to register online for EVerify before January 1st of 2021. No public contracts going forward as of the effective date is going to be entered into without that EVerify certificate. So if you are an organization that deals directly with public contracts, I highly, highly recommend getting signed up and get that certificate available to you because you will need it to enter into any new contracts in 2021. In addition, any subcontractor working on a public contract currently must provide the contractor with an affidavit, which basically must be retained by the contractor during the duration of the contract. And that affidavit is a signed statement stating that the subcontractor does not employ, contract with other subcontractors, or work with any unauthorized aliens. Contractors will need to go through this process for all of their current public projects. Also, in addition to that, private employers are not required to use the EVerify system unless they have a contract, again, with a public employer, or they apply for any taxpayer-funded incentives through the State Department of Economic Opportunity. So if neither of those restrictions apply to you in terms of this law, then this mandate will not apply to you. But again, if either of those do, then you will need to sign up for EVerify and get that document or get your affidavit for any current contracts that you have. All right, next we're going to go ahead and talk about two law changes happening in South Dakota in 2021. The first deals with the change to minimum wage. So beginning in January 1st of 2021, the minimum wage in South Dakota will be increasing to $9.45 an hour. In addition, tipped employees' minimum wage will also be increasing to $4.725 an hour, which is in accordance with the state's requirement that tipped employees be paid a cash wage of at least 50% of the state minimum wage. So what are the action items as far as this law goes? Realistically, you just got to make sure that you're conducting those wage audits every year when the minimum wage goes up, and identify any employees that will need that pay wage bump that will need to go into effect prior to the effective date. All right, next we're going to talk about the big law change that occurred in South Dakota during the November 3rd election. So there were two laws that passed, and these laws go into effect July 1st of 2021. So we have a couple more months before these officially take effect. But South Dakota passed both Measure 26 and Amendment A. Measure 26 legalizes the medical use of marijuana by qualifying patients. And then Amendment A actually legalized the possession, use, transport, and distribution of marijuana for adults ages 21 and older. Individuals may possess or distribute 1 ounce or less of marijuana, and the State Department of Revenue will issue marijuana-related licenses for commercial cultivators and manufacturers, testing facilities, wholesalers, and retailers. But local governments may regulate or ban the establishment of licensees in their communities if they choose to do so. So it's a lot of legal speak. So what does it mean? Well, first and foremost, state officials are being given until April 1st of 2022 to issue rules and regulations related to the commercial sale, cultivation, and anything regarding marijuana. So this law is going to evolve between now and April of 2022. So just be prepared to be flexible as these legislatures as these regulations start being pushed out by legislation. Now, the question that I know really kind of bogs down employers when we talk about the legalization of marijuana, which happened in many states over the November election. The question is always, how do these laws implicate employer rights? Well, they actually don't limit employer rights that much, which is good information for us. So Measure 26 and Amendment A do not stop employers from prohibiting employees from working while under the influence of marijuana or using marijuana in the workplace. However, Measure 26 requires that employers accommodate employees who use medicinal marijuana the same as employees who use prescription drugs. So essentially, you are still able to prohibit the use of recreational marijuana in the workplace. You're still allowed to do your drug testing if you have employees who drive for you and things like that. So it does not limit your employer rights in that regard. Just keep in mind that the law is still there under the ADA that you will have to accommodate medicinal marijuana usage, just as you would treat someone who is under the care of a doctor using any type of prescription drugs. The only exception to that rule with regards to the medicinal marijuana is if that would conflict with an employer's obligation under federal law or regulations. So for example, if you work or you have a company in an industry that is basically governed by the Department of Transportation, so truck, bus drivers, railroad drivers, transit system workers, or if you deal with hazardous waste materials, so pipeline workers, drilling agents, things like that, you will not have to accommodate that type of usage of marijuana given the position. So if you are regulated by any of those federal branches of the government, especially the DOT, then you would have to definitely look up what those exceptions are because you have a little bit more stringent rules dealing with the federal government. And then Amendment A does not stop employers from restricting the use of marijuana in the workplace or from firing employees who come to work under the influence of marijuana they use recreationally. Now remember, the distinction here is recreational versus medicinal use. So if an employee comes to work and you have reasonable suspicion that they are using marijuana and it is recreational marijuana, you do not have any medicinal documentation on hand, you are able to go through your company's processes as put forth by your employee handbook and use disciplinary action as you would any other situation where someone came to work under the influence of drugs or alcohol. So just keep that in mind, that these particular measures that were passed do not limit your employer rights in those regards. Now, as far as action items go, there are a few things that you can do right now to really prepare yourself for questions from your employees. It's really best practice to be preemptive and communicate with them what this new law means for the company, rather than just have them, read the news and the media and just think it's a free-for-all on recreational marijuana use, and then you find out the hard way that they're impaired at work. So one thing to keep in mind when you are communicating with employees or for your organization specifically, just remember that from a federal standpoint, use and possession of marijuana and their products is still illegal, even though it is legal in your state. Therefore, federal employees or any employees in federally regulated jobs or may even have federal contracts, you may still be restricted from using marijuana regardless of the state laws. So just keep that in mind if any of you deal with federal contractors or you have federal contracts. That is definitely something to keep in mind as this new law is evolving and we get more guidelines as to how it's going to be put in place. So as far as action items go, we're going to recommend that you start by looking at your current drug and alcohol policies to see if any changes or updates need to be made in the language to be a little bit more inclusive of the new accommodation requirements. So now that medicinal marijuana is legal, you may need to add in there about accommodations for medicinal marijuana or other prescription drug use. So definitely read over your policies and make sure that they are very general and all-encompassing in terms of not restricting any type of prescription drug or medicinal marijuana usage. Then after you do that, definitely communicate with your employees what the company expects in light of this new law. If you are still going to require employment drug testing or drug testing immediately following a vehicle accident, again, that is totally fine. You are not restricted from doing that. But remember that it is still illegal to discriminate against marijuana use for medicinal purposes. So just make sure that that is very clear in your communication with employees that this is recreational marijuana usage. And overall, when it comes to drugs in the workplace, this is definitely serious stuff. And I don't think we've seen the last of these laws. They will grow and evolve until the regulations have been put in place in April of 2022. So if you or your executive team or upper management team in the company are thinking of making any major changes to your policies in light of this new law, we highly, highly recommend that you speak to an employment law attorney just to ensure that your company is not taking on any unnecessary additional liability and just to make sure that you are still maintaining compliance with the law as it evolves and legislation surrounding the restrictions is released. All right, the next state we're going to talk about today is Virginia, and there is a lot of activity in this state, so we have plenty to talk about. So we are going to start with their minimum wage increase, which seems to be happening in a lot of states this year. This increase actually does not go into effect until May 1st of 2021, so you get a couple months into the new year before you have to hike up that minimum wage, but it is increasing to $9.50 per hour. Now, there are additional changes to remember. The minimum wage will increase every year in January going forward until it reaches $12 per hour in 2023. There is also a possible extension that is being discussed in the state to 2026, so an additional 3-year increase where they want to bring that minimum wage up to $15. So this will be pending the decision of the General Assembly in 2024. So after that change in 2023, by 2024, you should have an idea if they are going to extend the increases to 2026. So what are the action items that you need to take from an employer standpoint? Be sure to conduct your wage and audit and adjust any employees who will not meet that minimum wage in 2021. Also prepare to adjust their wages so their new pay will go into effect in May. Definitely not January if you don't need to. You have until May, so use that time if your company needs it. Also knowing that there is going to be a jump in 2022 and going forward into 2023 to get up to that $12 an hour increase, kind of same as my recommendation in Florida. Start preparing for that payroll increase and strategizing. If you have a lot of employees that are going to need that pay bump over the next 2 years, start figuring out, what's easier for you. Is it easier for you to do these annual increases, or would it be better to do more gradual stepping stones over the course of the next 3 years to get into that $12 an hour goal? So just something to keep in mind as you're strategizing for covering your payroll budget. All right, next in Virginia, we're going to talk about the new laws surrounding employee misclassifications. So this law goes into effect January 1st of 2021, and this law incorporates the IRS guidelines for worker misclassification. So according to the law, the Virginia Department of Taxation shall determine whether an individual is an independent contractor by applying IRS guidelines. Any occurrences of misclassification of employees made by the same employer at the exact same time or within 72 hours will be deemed a single offense. Now, this statute also provides that no one shall require or request that an individual sign an agreement or any type of documentation that results in the misclassification of the individual as an independent contractor. This can actually create liability for employers if they improperly classify individuals as independent contractors. I know sometimes for employers, it's very tempting when you're not really sure where to put an employee given their temporary status, and it's so easy to just classify them as an independent contractor. So just make sure that you are classifying them correctly, because they are really cracking down on this. Specifically, employers may be subject to civil penalties up to $1,000 per misclassified individual employee for a first offense, with increasing penalties for any repeat violations. So just keep that in mind as you are possibly signing independent contractor agreements with new employees, or if whoever is doing your misclassifications has a lazy streak and they don't really want to do the test and apply the test to classify the employee, just make sure that you are very careful about how you are classifying independent contractors. As far as next steps go, we do encourage you to review any current agreements that you have with independent contractors and just make sure that they are properly classified and that they meet all of the requirements before January 1st of 2021. We are expected to see a lot of classification audits coming in the coming years because so many states have really started to crack down, especially on independent contractor classifications. So as the government decides to send people out to audit these types of things and issue these civil penalties, we definitely recommend just kind of doing a self-audit and making sure that you would pass any audit issued by the IRS. All right, next we are going to talk about the law that passed regarding handheld personal communication devices while driving. So this law goes into effect January 1st of 2021, and this law prohibits holding a handheld personal communication device while driving a motor vehicle, subject to several exceptions. So essentially, this is a law that has passed in a lot of other states already, and Virginia decided to pass it in coming up in 2021. So no handheld personal communication devices. That includes things like cell phones, pagers, if people still use those, any type of walkie-talkie, anything that's a communication device. Now, there are a couple exceptions, and primarily they are for any operator of an emergency vehicle while they are engaged in the performance of their official duties. An operator who is lawfully parked or stopped. So obviously you can use these communication devices if you are stopped or parked. Any person using a handheld personal device to report an emergency. So if you're on the phone reporting an accident or an emergency and you are driving, or you're getting ready to pull off and park, anything of that nature, that is legal under this law. The use of an amateur or citizens band radio, or the operator of any Department of Transportation vehicle or vehicle operated pursuant to the Department of Transportation Safety Service Patrol Program. So essentially, if you are governed by the DOT, you have a lot of exceptions and leeway within this law. If you are not governed by the DOT or Department of Transportation, then this exception would not apply to you. Some action items for employers are if you have employees who drive for you on behalf of the company or in the process of performing work-related activities, you will need to add a policy in your handbook specifically stating and referencing the law and all the guidelines in terms of not using any type of handheld communicative devices. In addition, I would recommend including warehouse vehicles like forklifts and other industry-specific motor vehicles in this policy as well, because there really isn't a clear exception stated in the policy for any of these types of vehicles. In fact, in the law itself, it doesn't even mention public driving, like on public roads. So it just talks about motor vehicles, and technically forklifts and other industry specific vehicles have motors like golf carts, and they are considered motor vehicles. And some of them you do need licenses or certifications to drive, like forklifts. So I would include these in the policy as well, just to be safe and just to make sure that employees are being safe and they're not on any type of communication device, when they're lifting pallets with a forklift or driving a golf cart around your work premises. All right, and last we're going to talk about the state of Oregon. So Oregon only has one legal update in 2021, which is really a surprise, but it's actually kind of nice. It gives everybody a little bit of a break from previous legal updates that Oregon has gone through. But their minimum wage is increasing in 2021. The increase does not go into effect until July. So again, you guys have a couple of months to prepare for this increase. The minimum wage in Oregon will increase to $12.75 per hour for the standard rate, $14 per hour for the Portland metro area, and $12 per hour for non-urban counties. Now, there are additional changes to remember in Oregon. The minimum wage will increase a set amount each year in July until 2023, at which time it will then be adjusted based on the consumer price index each year. So Oregon's going to be going through significant minimum wage increases over the next couple years. And it looks like for as long as the consumer price index increases and inflation continues to go up, Oregon will have an adjustment almost every year. So kind of keep that in mind as you're budgeting and strategizing for your payroll. So as far as action items go, again, just make sure you're conducting those wage audits and adjusting as needed to make sure that any employees who do not meet that minimum are able to have that minimum go into effect before the effective date of July 1st of 2021. All right, well, that about wraps up our session today. I know that that was a lot of information to process, but take a second right now if you have any questions and feel free to put them into the question box. We will try to answer them the best that we can. Like I said earlier, these are new laws, so they may not have as much legal guidance as we would like, but we will do our best to answer any questions that you have and how they affect your business. Just as a reminder, this presentation was recorded and it will be available to watch again. To do that, you can visit www.payentry.com, hover your mouse over the webinars tab at the top, and click on webinar recordings. The most recent recordings will be on the top, and these are usually posted within 24 hours of the live webinar. You will also be emailed a copy of the webinar recording tomorrow afternoon. All right, Kathy, do we have any questions today?
You stumped everybody today. There are no questions.
I did. Oh, I'm so proud of
Yes, you
myself. That's a
did.
great webinar week before Christmas gift to myself.
Yes, definitely.
All right. Well, thanks guys for your attention today. I really appreciate it. I hope you learned a lot of good information. If you do have any questions or you think of anything after the fact, feel free to email me. My contact information is listed at the bottom of this slide. Also, next week, we will be covering a lot of states. So if you are a multi-state employer and you want to learn about state updates in any of these, we are covering Connecticut, Maryland, Maine, Massachusetts, New Jersey, New York, Pennsylvania, Rhode Island, and Vermont next week. So lots to talk about, lots of good information. Again, if you do business or you have employees in any of these states, I highly recommend you register for the webinar, and we will see you there next week. You guys have a great rest of your day.